Et à tous, bienvenue à cette midi-conférence sur le juge Scalia. Dont le décès soudain cette fin de semaine a créé une onde de choc sur la scène juridique et politique américaine. Nous avons même senti les réverbérations au Canada, comme le témoigne le grand intérêt médiatique et public manifesté à ce côté de la frontière. J'ai toujours soupçonné qu'il y ait un appétit au sein de notre communauté facultaire, professeurs, étudiants, membres du personnel, diplômés et amis de la faculté, pour ce genre de conférence portant sur l'actualité juridique. Et je pense que votre présence en grand nombre ont fait preuve. Matthew et moi, on va jaser. Ça ne sera pas la midi-conférence typique avec un discours de 20 minutes suivi par un autre. On va juste parler. On va aborder, vous avez, pour ne pas gaspiller du temps, vous avez de l'information ici sur Matthew et moi. Nous avons étudié tous les deux aux États-Unis. Matthew a même travaillé pendant longtemps comme professeur, notamment à George Washington University, et connaît très bien la scène juridique et politique américaine. On va parler, on va aborder 5 sujets, si le temps le permet. On aura une période de questions après. On va afficher sur l'écran les thèmes et les grandes décisions ou les grands écrits du juge Scalia qui tombe sous chaque sujet. Mais j'ai l'impression que le PowerPoint avance chaque 30 secondes, ce qui ne nous laisserait pas beaucoup de temps. J'espère être capable de gérer ça. Matthew et moi, on va jaser en anglais. S'il y a des questions en français ou des commentaires en français, on serait ravis de répondre dans la langue de Molière, mais pour la plupart, nos interventions seront dans la langue de Shakespeare. Right. Matt, did you ever meet Justice Scalia?
In fact, I have. I have met him on numerous occasions, and when I was at George Washington, he was an occasional visitor to the campus, and personally a very engaging individual. A colleague of mine described him. He was a big man and took up a lot of space in the room. When he was in the room, you knew he was there. He could be very cordial, very charming, but in a setting like this, he would love to engage. He once said that I love to fight. And so he would meet with faculty and students and very much engage with them in ways that were quite direct and quite aggressive. And he invited aggression back. He was not one who stood on formality a lot. And so members of the faculty would confront him and argue with him in front of others, and he would enjoy it. He would enjoy it very much.
I only saw him speak once at an event in Edinburgh, Scotland. And the auditorium was packed, of course, and he made a point of shocking the assembled Europeans as much as he could with his theories of originalism and textualism. Why don't we start by talking about that a little, about originalism and textualism, which are the two theories with which Scalia is most closely identified. Textualism, the idea that when courts interpret laws, they should look to the text first and foremost, not to legislative history, the work that was done by parliamentary committees or choice quotes that legislators might have dropped during the process, and not also or at least to be very sparing in the use of statutory objectives. And his point was that the text of the law is what's written. That's what governs. That's what Congress passed. And if an individual wants to know what the law is, what is prohibited and what is permitted, he should be able to read the text without having to have regard to the underlying purposes, which aren't necessarily written down anywhere. And Scalia, there's a great line in his book, A Matter of Interpretation, where he says that this the purposive approach to statutory interpretation is a bit like the Emperor Nero's trick in ancient Rome of posting the laws high up on the columns so that no one could read them, giving Nero maximum discretion in how he would enforce the law. And then there's originalism, of course, which is the idea that in interpreting constitutions, one should look to the original public understanding of the clause at issue, rather than adopting a living tree approach. One should look to the historical origins of the clause. What does cruel and unusual punishment mean? Well, it means what people understood it to mean in the late 18th century. What does freedom of expression mean? Same thing. But it's important to say as well, and in that Edinburgh talk that I mentioned, Justice Scalia made a point of saying that, and it comes out in the title of this essay, the 1989 essay in the University of Cincinnati Law Review, Originalism, the Lesser Evil. He didn't claim that originalism was the best theory necessarily, or a perfect theory. He just said it was better than the others. And his joke, which he told at the Edinburgh event, was, it's like the old story about the two campers who were woken in the morning by a bear marauding in their camp. And they both start to move, and one starts to run immediately into the woods, whereas the other stops and laces up his shoes. And the guy running away looks at the guy who's putting on his shoes and says, "What are you putting on your shoes for? They're not going to help you to outrun the bear." To which the guy lacing his shoes replied, "I don't need to outrun the bear, I just need to outrun you." And Justice Scalia, originalism just had to be better than the alternatives, right?
Exactly, and I think that the key aspect of that was it was for him a belief in judicial humility. Justice Scalia's theory, as you say, was text. I look at the text, I see what it says, I see if we can determine what it means by reading the text. If the text is ambiguous, then we look at what has been done. He was he took the position that if the text was somehow ambiguous, then we look at the tradition, and specifically what was done in the early years. What have we done over 200 years? The best evidence of what a statute meant is what the drafters actually did once it was passed. And so when he looked at constitutional provisions in particular, he would look at rights in that context and say, the drafters of the Bill of Rights may have drafted in such a way that today seems ambiguous. Does this, what did they do? They were the guys who passed it. Let's see exactly what they intended. His complaint was the updating. His fundamental problem was the idea that judges should take upon themselves to come up with changing interpretations, or to do the mise à jour, to update the text to changing societal conditions. His argument, both with constitutional provisions and statutes, was that this is the work of legislation, and that if these things are passed, if we believe in the democratic process, then it is the job of the judge to step back and let that process work. If a statute fails, if a statute is problematic, it's up to the legislature to make that change. And as I say, so his theory was very much one of constraining judges, preventing them from imposing their views, he, in several opinions, would say that what we have to do is to stop assuming that every single problem is capable of judicial resolution, that judges are not smarter than everyone else in society. In fact, he always made this point that judges aren't representative characters. First of all, they're lawyers, so they are not representative of society. And let's be clear that judges aren't even representative of most lawyers. They went, right now on the Supreme Court, they have all gone to only 2 law schools. They have all come from one of either the large cities, 2 of the large cities on the East Coast and 1 or 2 on the West Coast. They go through their day, they've all had very lucrative practices, either in government or in private practices. They go through their day surrounded by marshals. They enter the courthouse through secret doors. They never have to come into contact with the public. So why do we assume that they, of all people, are attuned to society's changing understanding? His argument was that if the text cannot be resolved, then it simply cannot be resolved, and we need to throw it back to the people. If in fact we believe in the people, if we believe in a rule by elites, then by all means the judges are the appropriate people to be updating the Constitution, or as we see in we see in Burwell, revising statutory texts to make them work.
There's also his quip. He had a debate with Justice Breyer, who was a colleague of his on the court, and Justice Breyer was complaining about originalism, and he said, it's what do we want on the Supreme Court? Do we want 9 historians? To which Scalia said, well, better 9 historians than 9 ethicists.
Exactly. I mean, that was his fundamental objection, as I say, that he has. And in the case you refer to, he consistently talks about the way in which judges are ill-equipped necessarily to do the kind of policy balancing. Remember, judges supposedly are deciding cases on the facts based before them. Judges are not legislatures. They are not capable of holding committees and striking a committee and engaging in large amounts of fact-finding over the course of several years. They are presented with an argument. The facts that are presented before judges are the facts that the litigants want the judges to hear, not necessarily all the facts. We all know that, right? And so his complaint was the idea that judges have that courts in general have a sense of society. What they have is a sense of how to resolve this particular case, given what the people's representatives have done. But the people's representatives are capable of having investigatory commissions. They are capable of having hearings that run months and years long. They're capable of having all kinds of experts just in off the street or be summoned or be requested. The people's representatives are far better at fact-finding and understanding the public policy implications of any policy than judges sitting on a bench who read briefs that are limited to 30 pages and an argument that is limited to 1 hour, and then suddenly they are supposed to determine public policy for generations. He says it's preposterous.
One of the things people say about him, there was an article by my friend Adam Dodek, who's a professor at the University of Ottawa, in the Ottawa Citizen yesterday, complaining that Scalia was, or not complaining, saying that Scalia was a little bit parochial. He didn't like to look to other jurisdictions to see what they do to inform how to read the American Constitution. Probably the best example of that, Matt, is his dissent in Roper and Simmons, a case about whether the death penalty for minors was a cruel and unusual punishment and therefore unconstitutional. And he took great umbrage at his colleagues' use of international comparative materials to justify striking down the state law in question.
Yes, his hostility to using foreign sources of law was matched only by his hostility to using legislative materials, or what we call the legislative history of a document. I can talk about the second in a bit. But when he, as you say, in Roper was a case about whether it was constitutional or whether it was cruel and unusual to execute children under the 18, minors. And Scalia's position was, nothing in the Constitution does not prevent capital punishment. The Constitution explicitly recognizes capital punishment in several instances. And since it doesn't say anything about the age, since it doesn't talk about minors as opposed to adults, it recognizes capital punishment. The text is reasonably clear. But even if it isn't, if the text is not itself reasonably clear, one need only look at the tradition. And he said, from the very start, young people have, when they have committed heinous crimes, been executed by the states. And so on this basis, I see no reason why we should now step in again and say society has changed. If society has changed, let the states do whatever needs to be done to change it. The majority in the case cited lots of cases from other jurisdictions, lots of European, UN Convention on Human Rights, European Union rights cases, and the Canada Supreme Court. And he reacted incredibly hostilely to this because he made the fundamental point. What you're doing here is you're picking and choosing cases and conventions and statutes of other jurisdictions that support your view. He says, taking a phrase that was Justice Harold Leventhal's earlier phrase, it's like looking over the heads of the crowd to find your friends, or cherry picking. I want this piece of law, and I want this piece of law, and I want that piece of law, but all these other pieces of law I don't want. And he gives several examples. He says, for example, Canada. He says, Canada rarely excludes evidence that is illegally or improperly obtained by the police unless it will bring the administration of justice in disrepute. But in the United States, the exclusionary rule is almost absolute. And he says, so what should we do? If we're going to adopt Canada's view of capital punishment, should we not adopt their view of exclusionary rules as well, which lead to capital punishment? He says on abortion, he says to cite Canada or someone else's rules is to say, well, Canada has rules about abortion, but in fact, only 6 countries at the time, only 6 countries in the world permitted abortion on demand. One of them was the United States. He says, if we're going to look at foreign countries' law on death penalty, why do we not look at foreign countries' law on the abortion questions? When the abortion questions come before the court, we don't all run around and talk about what the law is in Iran or China or other places. But when the death penalty case comes up, we do. And in fact, he in fact makes a joke. He says it's preposterous that the majority in this case has cited Iran as a place, as a model for human rights for the United States, that in Iran they do not execute young people. And he says, well, if we're going to adapt Iran's opinion on death penalty, then why do we not adopt its ideas on religious freedom, on the rights of women? And he says, and by the way, Iran executes homosexuals. Should we adopt that as well? So his argument is, I think, a rather pithy and consistent one. And the use of international law in this way, in which judges sort of run out and say, oh, here's a nice case, I like that one. Oh, this is a legal system we should adopt, I like that one. He says, you don't explain why you're not taking it all. What about these things? What is the principled distinction between saying, I will adopt Iran's position on death penalty, but I will not adopt Iran's position on these other issues? This makes no sense. But his fundamental point was that the American Constitution was not a document in which a group of people sat down, say, if you think about the Canadian Constitution in 1982, where people sat down and held long hearings and thought long and hard about this. The American Constitution, or the UN Convention on Human Rights, it is not a universal declaration of aspiration. He says the American Bill of Rights, and this is very true in particular, is drafted at a particular time for a particular group of people in a particular historical circumstance and is not designed to provide universal principles in the way, say, a European Human Rights Convention or a UN Human Rights Convention would be. The provisions are very limited and, as I say, designed for specific things. For example, you point out the Bill of Rights restrains Congress. It does not restrain the states. In other words, it says Congress shall make no law abridging the freedom of religion or establishing religion. And we know from very early on that the states, even after the provision, had established churches. The tradition was that the Bill of Rights was designed to limit Congress, the fear of a national government becoming overly powerful. So whatever the world might think about religious freedom or free speech isn't necessarily applicable to a document that was drafted in 3 months in 1789 to address a particular crisis in a particular nation's history. All the rest of it may be interesting, but it shouldn't be dispositive.
And that explains why for someone like Scalia, who's a common law judge after all, the United States is a common law country, and common lawyers do that, right? We cherry pick a little bit of Australia over here, a little bit of England over there in order to determine what the rules should be in Massachusetts or Ontario or wherever. And in his book, A Matter of Interpretation, he does make a distinction between constitutional interpretation, which is about what the U.S. document meant in the 18th century, and the common law, which is an evolving body which judges have been permitted to develop. And there they have much greater freedom, according to Scalia, than they do in the area of constitutional interpretation.
Can I just actually point out that in that line of Scalia, he once was invited to address the American Society of International Lawyers after saying international law is not useful for constitutional interpretation. And he took the invitation with relish and engaged. And at this meeting, he made 2 points. He said, first of all, surprisingly enough, I am the justice who cites foreign law most. I am a firm believer in foreign law. Of course, all the foreign law I cite is rather old, and it is all English. He had no time for the rest of it, but he did say this. He actually said, foreign law is useful. He said, I don't think Americans should ignore foreign law, but the foreign law stuff belongs in the legislative process. Congress should pay attention to where the conventions go, what the world is thinking as it devises its rights-based initiatives. It's not the job of the court to do that. And he did allow for foreign law in the interpretation of treaties in some ways in which other judges would not. He said that when the United States is a party to a treaty, using foreign cases or using foreign law to interpret that treaty, that would be acceptable. But in the interpretation of the United States Constitution, it had no place.
We move on to his legacy, a couple of examples of originalism and textualism in action. I think, just following on from the previous point, you'd have to accept, though, that, and perhaps this is evidence of his influence on the court, on the United States Supreme Court, that where in the 1970s or the 1980s, courts around the world, in my home country of Ireland, in Canada, in Australia, looked to the Supreme Court of the United States as a source of guidance and inspiration in matters of constitutional interpretation. That's really no longer the case. And perhaps it's no longer the case because American constitutional interpretation has become fixated on what the founders thought in the 18th century, whereas people in the rest of the world tend to take a more holistic view to constitutional interpretation. Is that fair?
I would actually disagree, at least to some extent. I mean, I think the Canada Supreme Court has been quite clear that it is disinclined to follow, for example, American jurisprudence on speech questions, because it is in fact too liberal. The Canada Supreme Court, while it will extensively talk about American free speech questions, then quickly retreats because, remember, in the United States, a hate speech law wouldn't pass it out of the district court. Hate speech codes, the human rights tribunals that punish for hurtful words and this kind of thing, that would be...
be careful, by the way.
Before I insult anybody. Yeah, okay. But if you read Canadian cases in that regard, it's not because of originalism. In fact, the Americans are much more tolerant of speech, and so in that regard, I think I should say this: much less tolerant of restrictions, government restrictions on speech, and so the Canada Supreme Court talks in terms of this American case law is interesting, but it doesn't quite apply here because we have other considerations or concerns.
And I suppose it should be pointed out that the Supreme Court of Canada often looks at historical materials and takes an originalist approach when it suits it, without doing it in an especially rigorous way. There was an unintentionally hilarious article in the Globe and Mail yesterday where the journalist talked to 3 former Supreme Court of Canada justices who said, oh, this originalism stuff is nonsense, it has no influence up here in Canada. The very last line of the article is a quote from Justice Binney, accepting grudgingly that the compact theory of confederation is something that does influence how the Canadian Supreme Court interprets the Constitution.
Exactly. And another place in which the Canada Supreme Court is incredibly originalist is in Aboriginal rights cases. In all of those cases in which we're trying to ascertain our relationships with the First Nations, the court has become, suddenly everybody's a Scalia up there. There's 9 of them, nine Scalia disciples on the court as they try to interpret what was meant and what was the original relationship and what is the meaning of the treaties and what did we understand to be the Crown's obligations. The Court on Aboriginal Affairs has become quite the devotees of originalism. But since you've raised the Canada Supreme Court, I would suggest that, and I think I could say this rather unconditionally, I think that Scalia would despise being a member of that court because for 2 reasons. One, he obviously, if you haven't got this sense yet, the whole idea of the living tree to him would be anathema. It is precisely the kind of jurisprudence that he says is entirely illegitimate for judicial officers. Again, that and particularly in Canada's case, he once might have suggested that if what you're interpreting is a statute, right? If the Canadian Constitution is in fact a statute, then then why do legislatures not have the right to amend or interpret the statute just as much as the court? And again, he gets into that same argument that you have a court that has taken upon itself to update it. Well, isn't that Parliament's job? Isn't Parliament the people's representatives? Why is it the court? Again, the elitism argument. And the other argument that he would, I think, despise, or I shouldn't say despise, the other problem that I think he would have a great deal of difficulty with is the Canada Supreme Court's tendency to, and I hope, well, I'll be insulting. It's what I do. This tendency of the Canada Supreme Court to act as though it's a mere trial court, to the contextual, the balancing stuff. Scalia hated that stuff. He said that our job as a court is to produce broad rules. If we are talking about facts, then we are doing the work of juries or administrative law fact finders. And that once a court starts talking about balancing tests, and here, right, we think about the Oakes test, we have 3 tests, but one of the subparts of it has 3 other parts of it, that once we have multi-factored tests and multi-factored things, and then in the end we just say, well, in the context or on balance, he says that's not the work of judges. That what we do is we establish the rules, and we need to be clear and definitive about what the rule is, and then leave this kind of stuff in the hands of the jury. In other words, he says that Supreme Courts really ought to abandon common law decision-making in that regard, that the lower courts are the places where this kind of thing ought to be done.
You know, I have a section on rules and standards, which I might skip to. I just want to mention District of Columbia and Heller, which is the decision where the 5-4 majority in an opinion authored by Justice Scalia recognized that the Second Amendment to the U.S. Constitution protects an individual right to own and possess firearms. And what was striking about the opinion, and what has led some observers to describe it as Justice Scalia's triumph, is that both the majority opinion and the dissent proceeded on the basis that what mattered was how this clause was understood when it was adopted. Now, they came to very different conclusions based on the evidence, which perhaps demonstrates some of the perils of originalism in practice, of asking judges to be historians. But certainly their starting point was the same, and I don't think it certainly wouldn't have been the case 30 years ago or 50 years ago if you go back to the opinions of the Warren Court on civil rights or on racial equality. There's often not even a passing reference to what the founding fathers thought about something. But there is a question about his overall influence and whether he was really able to get his colleagues to go along with his judicial philosophy in the really big cases. And one of the really big cases in recent times is King and Burwell. This is the second case, the second major case about the Obamacare legislation, and in particular it was the implementation of tax credits by the Inland Revenue Service, and the question was, what is the
That's the Internal Revenue Service for those of you who need a translation.
Excuse me. One of those
evil government agencies. Yes.
Yeah. So the point is, what do the words "established by the state" mean? And is it fair to say that the majority opinion in that case, written by Chief Justice Roberts, discarded textualism because it was inconvenient? It would have, if you were to read the phrase literally as Justice Scalia, or textually I should say, as Justice Scalia would like, that would have wreaked chaos. It would have completely undermined the whole Obamacare regime. Doesn't that demonstrate to some extent that Justice Scalia, while he has been very successful in developing these theories and in making them the starting points for analysis on American courts, has not succeeded in, or did not succeed in, convincing his colleagues to go with him all the way and apply originalism and textualism to the bitter end in all cases? I have so much to say about that case, which I will leave for the moment. I guess that's the legacy question. And I think that it is great. Justice Binney, I suppose, in the Globe and Mail yesterday talked about, well, how his influence would have been greater had he been nicer to people. It is from a distance, and especially if all you do is get your news from the Globe and Mail, you are likely to miss his influence. Because one of the things that is underestimated, or one of the things that seems difficult at a distance, if you're just looking at the opinions and seeing how they come out and who's in the majority and who's in the minority, one of the things that is quite overlooked is the influence that he has in the entire way in which the court has gone about doing its business. I once said about 2 or 3 years ago to my American constitutional law class, one cannot be confirmed as a justice of the Supreme Court, and one cannot function in the Supreme Court unless he or she has some originalist
tendencies. There's no justice, there's no prospective justice who's going to go before this Congress and say, I don't care what the original intent was. He will not be confirmed. Will not be confirmed. The originalist, textualist mode of decision-making has, if not taken a majority of the court, every member of the court must engage with it. The fact that, as you point out, the fact that Justice Breyer has to engage indicates the importance of it. Because if it were this weird little thing that Justice Scalia does, Justice Scalia would be a party of one. The fact that Justice Scalia gets two, three, four others to follow along with him indicates that originalism has force. And even when he is in the minority, they do not ignore the originalism arguments. The court has to engage Justice Scalia and his originalism. We also do not see here, at this distance, we're like 30,000 feet, we also do not see here the tremendous impact that Justice Scalia has on the academy, the lower judiciary, and among students. I once had a colleague say to me, this was at George Washington, and he said, I sometimes walk in the classroom and I think I'm the only living constitutionalist in the place. All my students are originalists now. Just this way of going about the business. We forget that the Supreme Court of the United States hears 1/20th of 1% of the cases decided by the courts of appeals. The courts of appeals are massively stocked with originalists. They are many, right? We've had Reagan, we've had 8 years of Reagan, we've had 12 years of Bush appointments, and even some of the Clinton appointments. We have a firm supply of originalists throughout the judiciary taking their cues from Justice Scalia. So his view of legislative history, his view of textual history, may not command majorities in 5-4 decisions on the Supreme Court, but he is clearly a force to be reckoned with, both in the academy. I mean, think about how many books have been written on originalism and symposia and textualism. It's an entire cottage. I mean, here in Canada, if you stand up and advance originalism as a interpretive method, everybody sneers or snickers. They're polite,
That's
but
not
snicker.
true. They appoint you to the Ontario Court of Appeal, like Grant Huscroft and Bradley Miller. I mean,
in the academy, I should say in the academy.
Professor Eric Posner wrote a piece for Slate. He's a professor at the University of Chicago Law School. Wrote a piece wondering whether textualism and originalism, which are now huge fields of scholarly inquiry, will survive Justice Scalia's death, because he was the focal point for these schools of thought. And it's true that even those who would consider themselves liberals and not conservatives in matters of constitutional interpretation and statutory interpretation have taken up Justice Scalia's challenge. I think notably of Yale law professor Jack Balkin, who wrote a book in 2011 called Living Originalism, where he looks to demonstrate that the historical understanding of the Constitution was to permit courts to develop some of the broad language in the Constitution, like the Equal Protection Clause, the Due Process Clause, and so on. So it is true to say that he has had an influence, even though many of the cases that we're going to see on the PowerPoint are dissenting opinions. He also said from time to time that when he dissented, he wrote it as much for law students as for anyone else, as much for new generations, coming generations, which he could influence, whereas his colleagues might have been past convincing. Let me skip to the rules and standards cases, because you mentioned this antipathy of his towards the idea of judges doing balancing and using open-ended standards. And there's a terrific essay that he wrote. He was very productive in 1989. He wrote a few articles in law journals which have the great advantage of being short. They're all somewhere between 10 and 20 pages, which is more than one can say for most of the literature in American law journals. And in the rule of law as a law of rules, he says that. He says what judges should aim to do is to establish general rules rather than engaging in using standards and balancing, which is basically glorified fact-finding, which is not the proper role of an appellate judge. And he says at one point in that essay, there are times when even a bad rule is better than no rule at all. Better to have a rule which is clear and maybe wrong than a standard which allows endless debate and uncertainty and judicial fact-finding.
Yeah, and there's a number of reasons for that. One of the things that he says in that article is the idea that the Supreme Courts, any Supreme Court, operates as a traditional common law court is actually detrimental to the process, because as he points out in the article, that we take this idea that the court is going to continue to refine. And he points out, or he says, this idea that the court will close in on the right rule in that traditional English common law sense. Well, I decide this question with these 5 facts, and then the next time the case comes up and it's got 5 facts plus 1, we'll have another chance, and then another time it'll come up and it'll have 5 facts less 1, we'll deal with that. This sort of very technical common law decision-making, he says, is really inappropriate for the Supreme Court, because the court rarely comes back to this stuff over and over. It gets an opportunity to do, for example, a gun case once every 20, or actually in Heller, it's the first. Right? So the Constitution is playing around here for close to 200 years, and it takes it almost more than 200 years to get to a case definitively interpreting the Second Amendment. So he says this kind of case-by-case, just deal with these facts, this context, this balance here, works at the trial court level where there's an appeal to an appeals court. It doesn't work at Supreme Courts, where what we need to do is announce a clear rule and let everybody else do the balancing. We won't get back to this in any reasonable amount of time.
And this is most notable in his administrative law jurisprudence. I mention his essay on judicial deference on administrative interpretations of law because it has one of the best opening paragraphs of any law review article ever. He starts by saying, I was hoping to talk about confirmation hearings and about abortion, but I was informed that the topic is administrative law, so hold on to your seats and get ready for a rough ride. Administrative law is not for sissies, which is true, as I tell my students. But you see there, City of Arlington and Federal Communications Commission, this is an example of his preference for rules over standards in evidence in the area of administrative law. So in his 19th judicial deference article, he talks about what is called Chevron deference, the idea that where a statute is ambiguous and it is administered by an administrative agency, like the Federal Communications Commission or the Federal Election Commission, the court should accept the agency's interpretation and not impose its own. Where the statute's ambiguous, the agency wins. And in City of Arlington, he extended this rule to so-called jurisdictional questions. And the difficulty with the idea of jurisdictional questions has always been, this is true anywhere in the world, it's very difficult to have clear rules about what is jurisdictional and what's not jurisdictional. It basically ends up as an invitation to case-by-case standard setting. And in City of Arlington, he says, for these questions, we're going to apply Chevron deference. Not a position which pleased the more conservative members of the court, Chief Justice Roberts, wrote a very strong dissent from Justice Scalia's rule-based approach. But you can see that in some of these decisions, and perhaps Hamdi is another example, Justice Scalia took positions because of his preference for rules over standards that pleased liberals more than they might have pleased conservatives.
Yes, he was. Did you want me to do the whole rights thing, or?
No,
yeah, just that one.
Just do Hamdi.
Yeah, Hamdi is a good example of that. Hamdi is a Guantanamo Bay case, and we all know that Scalia is that evil conservative who hates liberals and all the rest. And Hamdi comes out in a very interesting way. The question: Hamdi is an American citizen, and he is being detained at Guantanamo Bay. And he is supposedly going to be held until such time as there is some military commission. And Justice Scalia, reading the Constitution's habeas clause, which says that the writ of habeas may not be suspended except in time of war and by an act of Congress. And the majority upholds unlimited detention, including of American citizens at Guantanamo Bay, on the basis of the context and the situation, and it's a time of great emergency, and we're going to defer to the executive in this on balance. And Scalia says, no balance here. The Constitution is very clear. The Constitution says the writ may be suspended only in times of war or rebellion and only upon an act of Congress. The president doesn't have the power. And so therefore, in his dissent, he says the Hamdi and another elsewhere working its way through the system, Padilla, both are entitled to be either to be released immediately or to be brought to trial immediately. There's no third option. There's no unlimited detention. The Constitution says what it says, and if that means, and he says, I do not know what the national security effect of my decision is, but that's not my job. He's very clear. If this makes national security more difficult, that's not my problem. My job is to read the Constitution and apply it. And if there are national security implications, if this puts the nation in danger, then that's for Congress and the president to figure out. Basically, he says, it's for Congress to go and pass a statute in accordance with the Constitution, suspending habeas. And until such time as they do that, then the writ should apply and Padilla, or Hamdi should go.
Let's just mention it doesn't quite follow in a linear fashion from what you've just said, but Oregon and Smith is a very interesting case about the free exercise of religion clause, about communities in Oregon who were using peyote they use it for religious purposes, their own spiritual purposes, and this was outlawed by a general law of neutral application. And Justice Scalia said that this was okay. If a general law of neutral application has an effect on the exercise of a community's religious freedom, well, that's just too bad. And it's just too bad because what he would prefer is a general rule which is clear and objective and everyone can understand it, rather than a case-by-case balancing approach where the Supreme Court and the Courts of Appeals time and again would have to look at how important the state interest was, how big the effect is on religious communities, and determine whether or not the free exercise clause had been violated.
Yeah, I think he would have opposed the Section 1 analysis.
But the interesting thing is that the transparency of that analysis permitted Congress to enact the Religious Freedom Restoration Act in response. But perhaps not to. Have I got my?
No, that's exactly it. I mean, again, Justice Scalia has this reputation as the great, the arch conservative, but this is a decision that conservatives despised. He, as Paul says, it resulted in in Scalia's case, a bright line rule, that there weren't going to be a balancing test. If this is a law of general application, then it applies to everybody, and there are no religious exemptions for it. That was his position on this. Unless it it specifically is designed to affect religious liberty. Then, so for example, as driver's licenses pictures, right? People may object for religious reasons to having their picture taken on a driver's license. His answer is, doesn't matter. Applies to everyone, everybody, and the fact that your religion won't let you do it, that's basically too bad for you. What it does, Congress reacts very quickly, within I think 90 days, and passes the Religious Freedom Restoration Act, which is a congressional overruling of a Supreme Court case. And when you would ask Scalia about it later, he says, well, that's the way the system works. What I had was a text, and I applied it. And if the people believe that I'm wrong about that, that's what statutes are for.
All right. Let's go back, and this will be the last thing we do, and then we'll have questions. Here's a long list of cases, which I've entitled Rights and Federalism. And I guess the idea here is to see how does Scalia's originalism cash out in these areas. Some very important cases here, United States and Virginia, about sex discrimination. Texas and Johnson is the flag burning case, the First Amendment. Coy versus Iowa is a case about criminal accused's right to see his accuser testify. Romer and Evans, gay rights after a referendum in Colorado. Lee and Wiseman, school prayer. Planned Parenthood and Casey, abortion, interpreting Roe v. Wade, and Prince in the United States about the extent to which the federal government can commandeer state authorities. There's some general points that we can that maybe come through these decisions for you, Matt.
Yeah, if you look at the list, they invoke a variety of individual rights. And in every single one of them, you can see Scalia. Sometimes he's in the majority and sometimes he's in the dissent. But he is consistent throughout in his text and tradition approach. The first case, O'Hare Truck, involves a government contractor, not a government employee, a government contractor who criticizes the local government with whom he has the contract. They cancel his contract. He asserts it's a denial of his political expression rights. And Scalia here says no violation. Because the tradition, the text of the Constitution doesn't specifically speak to this government employee, government contractor relationship. And from the very beginning, governments had the power and did frequently punish those who criticized them or disagreed with them in the earliest days. It was the whole patronage system. Your guys are out, my guys are in. And his argument there was, the First Amendment says speech is free, but clearly the framers understood that to be not entirely free. Well, and he always would point out that's where libel laws come from. Libel laws are a restraint on speech, and they're not mentioned in the Constitution. Texas versus Johnson is the sodomy case.
No, that's Lawrence in Texas.
Oh, I'm sorry. Texas versus Johnson is the, I'm sorry, I have the two Texas cases. Texas versus Johnson is the flag burning case. Here, he enraged the conservatives by saying the amendment says nothing about burning a flag. And the Constitution protects expressive speech. A protest march, he says a silent protest march is in fact speech. Burning a flag is speech and therefore is protected. That was immediately followed by a flag burning statute. Coy versus Iowa,
proposed several proposed
proposed amendments, yes.
Of course, the American Constitution is impossible to amend, or very difficult to amend. So
unlike here, right. Coy versus Iowa, he read the confrontation clause, and this involved a rape case, and he said the procedure was that the accuser would be in a different room and would appear by video or behind a screen.
They were kids.
And they were
yeah, young children.
Yes, they were young children. The appeal was upheld. Justice Scalia would have upheld the appeal on the grounds that the Confrontation Clause means what it says. I have the right to confront my accuser, to see my accuser, and to have the accuser accuse me in an open court in front of other people. And he says in that case, of course, he says, yes, it does make it difficult for certain groups of people, but right, how else do we judge credibility? And he even points out that it will, on occasion, result in a malevolent accuser having to back down. But he says the Confrontation Clause basically means what it says and doesn't get to be updated. Romer versus Evans.
I'm just going to pop in on Coy in Iowa. In his article on originalism, the lesser evil, he says that this is an example of how originalism might give an individual broader rights than a living tree or a living constitution approach. So he says, well, if we look at the practice at the time the document was written, it's clear that confront meant to be able to see your accuser. But if we developed a theory of emotional trauma that certain groups are going to be so scarred by the adversarial process that we need to roll back, we need to scale back the protection for the accused, that would lead to a diminution, a reduction in the right as understood at the time the Constitution was adopted. Now again, we can debate whether that's good or bad. It's certainly not the position in Canada, which permits, which is much more permissive in respect of testimony. But it is an illustration of how an originalist approach, by freezing rights in time in the 18th century, can augment the protections that people, criminal accused have.
Right. And Romer is an interesting case. It was a Colorado Amendment 2. It has to do with homosexuality. And it was an amendment to the Constitution which prevented the state from giving preference to persons on the basis of their homosexuality, basically an anti-affirmative action provision. To say, in other words, the state might give preference to blacks, to women, to various groups, but it would not be permitted to give preference in any state-run program to homosexuals. They were not a discriminated group on the level of blacks or women. And Scalia's answer to this, the court struck down the provision. Scalia's answer to that was the Constitution says nothing about homosexuality. There isn't any provision in there. And in fact, the states have had numerous provisions on the books outlawing homosexual conduct, and the Supreme Court itself had upheld restrictions on, had upheld sodomy laws just 10 years earlier. And so he says that just 10 years ago, this very court allowed states to criminalize homosexual conduct, and now this court is saying, we're changing our mind with respect to this, that suddenly there's a protected class here, and he says, I don't know how we got to that. The Constitution is silent about homosexuality. It is left to the states to regulate on their own.
And that's something that comes through in his dissent in Texas v. Lawrence later on, yes, where the Supreme Court struck down a statute criminalizing sodomy, and again in Obergefell and Hodges, the case where the majority, written by Justice Kennedy, recognized a constitutional right to same-sex marriage.
It is also where he goes in Planned Parenthood. It's an abortion case. He says, the Constitution doesn't discuss abortion. There's no provision that remotely, in his view, gets you to striking down restrictions on abortion. And he says, as a result, we look at the tradition. We see that the states have regulated abortion for as long as they have been in the business of that kind of regulation. And so therefore, in the silence of the Constitution, we look at what the states have done, have always done, and therefore we don't invent a new right in the emanations from the penumbras, if you will. That's someone else's phrasing. But Lee versus Weissman is a religion case. It's a prayer, the invocation delivered at the high school graduation or at a school graduation. And here the court strikes it down and says, well, that's an establishment of religion, to have a person, a minister in this case, or a rabbi, step forward and deliver a prayer at a publicly run event, a government-sponsored event. It is the government establishing religion. And Scalia says, well, the tradition is that this happens all the time. The government-sponsored events from the very beginning involved prayers. In fact, the United States Congress employs full-time chaplains whose job it is to deliver prayers before every single session of Congress. This court, he says, this Supreme Court of the United States opens with a prayer each morning. So the idea somehow that we've reached the point now where a generic, non-specific, non-denominational prayer in 1992 is somehow unconstitutional when it has been constitutional. And in fact, even today, Congress still begins with a prayer, and so does the Supreme Court. He says this makes no sense whatsoever. And so you see in his view, it's, does the text deal with this? If not, what have we done? The best interpretation of what the text means is, what have we always done?
All right. We don't really have time to get into the politics of his replacement.
That's what happened.
Mais si quelqu'un pose la question, on serait ravi d'aborder le sujet. Alors, on a une petite période pour des questions. Alors, vous pouvez vous livrer. Pierre. Oui, OK. Pour les heures de reconnaissance pour la formation continue, il y a des feuilles. Je remercie Pierre Lesage et mon adjointe Sarah Richard. Bon, Sarah a préparé le PowerPoint et Pierre a préparé le formulaire que vous avez rempli afin de vous inscrire. Et je les remercie. Bon, des questions, des opinions à livrer, messieurs?
Yeah, it's not an opinion, but I'd be happy to hear about your thoughts on a replacement.
See, I told you, that's the sexy stuff, right? Who cares? The guy's dead.
In other words, the politics of it?
No, not the politics.
The process?
All the rules. There's any rules that would in any way stop a nomination.
Well, yeah, easy. It's important to bear in mind this. Be careful what you read. Sorry to those of you who are journos, but a lot of times they get it wrong, or there's an agenda. The Constitution of the United States says the president shall nominate the Senate and appoint after the advice, or with the advice and consent of the Senate. There's this tendency to assume that President Obama is entitled to get his choice. That's not at all the way the system is designed to work. The system the framers created is explicitly political. It is explicitly designed to ensure that in other words, the framers of the American Constitution, as Justice Scalia will fondly tell you, had a great hostility to executive power. The idea that that the president just sends a name up and everybody's supposed to appoint or approve it is entirely contrary to the history. And particularly since 1967, we've had a number of Supreme Court justices who have been rejected by the Senate, in every case by a Democratic Senate, a Republican appointment rejected by a Democrat Senate. So the process is designed to be political, and for good reason, right? We are to make sure that the people's representatives have some say in a court that has as much power nowadays and has life tenure. Why wouldn't Congress be involved in this decision? So we will see this play out, and I think, and from my perspective, constitutionally, perfectly appropriately.
And he'll try and nominate. He'll nominate someone who appeals to the base of the Democratic Party, and the Republicans will block that person, and they'll make a big song and dance in the primaries and the election campaign about this. And the nominee, president, can nominate whomever he wants, but he needs a majority on the Judiciary Committee to permit it to go to a vote, and then the person needs to win an up and down vote in the Senate. And I think most clued-in observers would say these things are unlikely to happen before the end of President Obama's term.
I may be mistaken, but when the framers, when the first government in the United States, there were no political parties. So how could that have factored into their analysis of the Senate? The consent of the Senate was thought of as a body of independent senators, not political parties vying for control of the president.
Well, Matt's the originalist, so he can answer this.
I think parties merely amplify today, but first of all, it isn't. I mean, parties developed in the United States very quickly, very, very quickly. We had established parties probably by within 5 to 7 years. That is to say, not with formal membership and all the rest of that, but we certainly had factions immediately. Throughout all of the debates of the Constitution, there are numerous references to faction, and the idea that Congress was going to be a mess. The system was designed to move slowly. The system was not, the entire federal system was designed to move incredibly slowly. It was supposed to be very difficult to get anything done, again, because of the fear of the national government. They didn't want an efficient system. And as I say, it's not really a function of party. It could be a function of region. Northerners don't like Southerners. You could have that kind of battle play out. And that was a very fundamental battle. In the early Supreme Court, the choices were very much dependent on region, making sure that every region was represented. Certainly by about 1800, it was very clear that party was all in all on his retirement. We all know Marbury versus Madison was all about party politics. So the fact that there weren't organized political parties does not really relate one way or the other to whether the framers of the Constitution assumed that a president would just send a name up and everybody else would jump in lockstep. I think the framers would have thought that was really not a good way of going.
If we say that Scalia is more or less the guardian of originality and textual side of things, with regards to that, do you think that we're going to see more decisions coming from the Supreme Court on more of the realism side, or something more based on morality, and we see different types of decisions?
In fact, is what I meant about earlier when I said everybody's an originalist. I don't think I've ever heard a Supreme Court judge say, I don't believe in originalism, I don't believe in textualism, I'm a living constitutionalist. Nobody says that out loud.
Not anymore. Justice Brennan used to.
Yeah, he used to say that, and he's dead and gone, and which of course gets into that legacy question. President Obama knows that President Obama has two choices here. To try to do a consensus choice, which I think is unlikely, and instead to pick a provocative choice. So he might pick a living constitutionalist, which would just be waving a red flag to entice the swarm. This nomination, I think, will likely be an important presidential issue. Both sides need the issue. And so I think that we will not, unless... First, it will be, one, hard to find someone who says, I'm a living tree kind of guy. Two, that guy isn't getting through.
And there are still, Justice Thomas is still on the court.
Oh, yeah.
In many ways.
Justice Alito is in many ways more conservative.
Alito is maybe more conservative, and Justice Thomas is a more full-blown originalist. Scalia, in his article, describes himself as a faint-hearted originalist, whereas Justice Thomas is he's Full Metal Jacket.
Yes, that's actually a good point. I mean, I'd forgotten that. You're right. I mean, Justice Scalia almost never describes himself as an originalist. He always describes himself as a textualist. He goes to the originalist side when the text doesn't help. Then he says, I want to know what was going on. But his originalism is the fallback provision. Justice Thomas, on the other hand, says, what did the word mean in 1789? And that's what it means now.
And that means that whoever comes on the court next is not going to get a free ride. They'll have to answer to Justice Thomas and Justice Alito, maybe. Sorry.
I think it would be fair to say that for Scalia, thinking about the Constitution as a living tree is really just the Constitution as a fig leaf for liberals who want to interpret laws. And wouldn't the thin edge of the wedge be right where you just placed it? The distinction between textualism and originalism. I mean, perhaps this is more epistemology than law, but the reality is that you can't posit a textualism or an originalism without a textual theory of textualism and an originalist theory of originalism. Because who has got the monopoly even on the historical bailiwick? I mean, if you want to deconstruct all of this, you've got to go back to what the founders may have ate for breakfast and who. Hey, let's remember at the beginning of the American Republic, you weren't going to turn to America for interpreting your laws, were you? You would have to go back to the old country. I mean, an American revolution is also a legal revolution.
I'm going to say two things, then you can jump in.
Nope.
First, I think that's a great point about what did the founders think about originalism, and there's some evidence that they weren't very originalist. But what's interesting is there's a whole cottage industry of originalism scholarship that has grown up since Scalia's 30 years on the court. And there are a couple of scholars, a guy called, I think it's Mike Rappaport, who has developed his theory of what he says are originalism methods, looking exactly to what methods the founders would have used to interpret the Constitution. That's just one of the many varieties of originalism that's out there. Original methods, originalism. The other thing to say is Justice Scalia had a quip as well about living constitutionalists. He said, you know, when I go home to my wife at the end of a long, hard day at the court, I sometimes am downcast because my originalism or my textualism led me to a conclusion that I do not personally agree with. Whereas it's much easier for the living constitutionalist who goes home, has dinner, sits down with a glass of wine and says, hey, you know what, honey? Today we had a constitutional case, and guess what? The Constitution turned out to mean exactly what I wanted to mean.
Yes, with respect to your point, I think that Justice Scalia would freely admit that his method is imperfect. In other words, what he always suggested was it's better than the other methods because, again, it's the only one that constrains us. Otherwise, we have a court which is then taking on legislative functions. And he doesn't really, the reason he says I'm a faint-hearted originalist is because, as I say, he wants to look at the text, see what it says, interpret it if we can. Then he says, I want to see what we did. And he doesn't mean just in 1789. He says throughout, how long, this is a long tradition. For example, the abortion cases and the gay rights and the same-sex marriage cases, his answer to that is simple. We don't need to know what anybody really thought in 1789. One thing we're almost certain of, none of them had ever considered these ideas. None of them had ever considered whether the Constitution guaranteed abortion rights or same-sex marriage. He says, as a result, I don't need to really do it. Originalism isn't going to help me there. We're pretty sure we know this was not on the radar. The question is Is this something the American people recognize as a right today? If so, let them say it, not us. Otherwise, we are just a supra-legislature constantly amending the thing.
And with that, Matt has to go and teach at 1 o'clock. Thanks a lot, Matt, for participating in this. And thanks to, merci à tout le monde d'être venu. J'espère que vous en avez tiré quelque chose de notre discussion. Et bon, à la prochaine fois, on espère, petite midi-conférence portant sur l'actualité. Merci beaucoup. Merci.